Welcome to the second episode of Sage 3 webinars. If you missed our first webinar on what leadership mindset do I need, a link to the recording of the webinar is available in the chat box. Today's webinar is organized in collaboration with two of Malaysia's leading lawyers and powered by Leaderonomics. Today we shall be discussing the topic, what is my best restructuring option? But before we commence, let's see how many people we have participating with us today. I believe that we had 121 and there were quite a lot of people still waiting in the waiting room, so welcome. Please send in your questions during the session and participate in the polls. There is time allocated at the end for Q&A. To submit the questions, just follow the instructions which was conveyed to you by our administrator. For those of you who are new to Sage 3, just a brief introduction. Founded in 2005, Sage 3 are specialist advisors in debt restructuring and fundraising. Today, the firm has 7 partners and restructured debt in excess of 20 billion ringgit since inception. Sage 3 is trusted and respected by the financial and business community and is known for constantly originating innovative, out-of-the-box solutions. On that note, a brief introduction of myself and the speakers today. I'm Zaha, Rina, and I joined the Sage 3 team in 2009 after returning from the Gulf, especially Bahrain. I had worked with one of the founding members, Davin Fernandez, in Bursa, Malaysia, where he was Chief Technology Officer and I was Head of Exchanges and Business Development. We worked together then very well and still do today. From Sanjay Mohan, Mr. Saheran Suhendran. Suhendran has been in practice for 35 years, including a partner in Kadir Andri & Partners, and has extensive experience in corporate and commercial disputes, as well as corporate restructuring and insolvency work. From Tommy Thomas, Sitpah Selvaratnam. She has been practicing law since 1991, focused on corporate insolvency, commercial and shipping litigation, and disputes. Sitpah was the founding partner of the firm Tommy Thomas and represents diverse Malaysian and foreign corporations and commercial interests in High Court and Appellate Courts in Malaysia. From Sage 3, we have Devon Fernandez. Devon began his career in ASEAN Bankers Malaysia Berhad, now Malaysia Maybank Investment Bank, before joining Sage 3 in 2009. His extensive experience managing corporate transactions includes several substantial deals demonstrating the significant market understanding that he offers to clients of Sage 3. He also has more than 10 years experience in corporate debt restructuring. We have worked directly with Tommy Thomas as expert witness for a major legal case and sat through multiple challenges on a scheme of arrangements with Suhendran, which all resulted in eventually a successful restructuring. Additional information of the companies along with their respective contact details will be provided in the handouts to this meeting. In the first episode, there were discussions about corporates being agile and adapting in times of crises. In fact, there has been quite a bit of discussion on the first mover advantage. But how do we get to the first mover advantage when we need to decide on the process to take in respect of restructuring? We shall consider the options available to companies that wish to restructure and provide you with practical knowledge that the speakers have gained from restructuring engagements they have undertaken. To begin the session, I shall now invite Devon to provide a brief description of the case studies that have been selected just for the example. Devon? Okay, perhaps I could just continue that the first case that he was going to go through is a Mega Steel, which is our Malaysia's hot rolled coil producer, and its total debt stood at 4 billion, with the large amounts owing to local and foreign banks related to companies, employees, trade creditors, and TNB. Mega Steel was admitted to Bank Negara Malaysia's Corporate Debt Restructuring Committee in 2012, and the debt settlement proposal was accepted 100% of creditor institutions present and voting at the court-convened meetings held in September 2019. This process took more than 3 years to obtain approval. The next example is actually Hanjin Shipping, which was the 7th largest container shipping line in the world, and it had a total exposure to creditor institutions of US dollar 4.9 billion. There was an attempt to restructure directly with its creditors, but inability to obtain the required financing and difficulties in carrying on its operations led to its demise. Ultimately, Hanjin was declared bankrupt by the South Korean courts with total debts of 10.6 billion US dollars liquidated. The trustee appointed to oversee liquidation has only recovered 220 million US dollars, which is just a 2% recovery. So with those examples and those staggering numbers, what options are available to a company that wants to pursue restructuring? Devin, are you back on the line? All right, let me check. Let me just go on. Perhaps, all right, before we undertake any restructuring and an assessment of what caused the predicament of the company in the first place, we have to check. And what can be resolved to restructuring is required. In the case for a viability can be made, then there are a few options available to the company to undertake this restructuring. The company could carry out a restructuring under Section 366 of the Companies Act in 2016 through a scheme of arrangement. The option involves the company obtaining the approval for creditors of a meeting to consider the debt settlement proposal. This is followed by a court sanction and the debt settlement proposal. Another option to restructure informally is by engaging directly with its creditors. Recently, through provision of the Companies Act 2016, two new avenues are available to companies, namely the Corporate Voluntary Arrangement, the CVA, and the Judicial Management, JM. However, as CVA only applies to private companies with no secured debt, its focus is very limited, and we will not consider this in detail in this session today. Judicial management does not apply to companies subject to the CMSA listed entities, but can be applied to subsidiaries under the listed company. Lastly, we have the company can opt for debt restructuring under the auspices of CDRC, which provides a platform for viable corporate borrowers and their multiple financial creditors to work out feasible and market-driven debt resolution through mediation without having to resort to lengthy, costly legal proceedings. Companies that fall within the definition of SMEs can apply to Bank Negara's small debt restructuring scheme. So on that, Devon, you are back and are you back?
Sorry.
It's okay.
I think I am.
Just
sorry.
went, it's okay. It's okay. I've just gone through the comprehensive listing of available restructuring options for which is Section 366 Scheme of Arrangement, Informal Restructuring, Corporate Voluntary Arrangement, Judicial Management, CDRC, and Sdrs. How does one decide which is the best option for the company then, David?
Good question. And when you decide on which option is best for you, you need to understand the characteristics of each of these options. Now, I think first off, let us consider the scope of the various options that are available. Okay, so under CDRC, you will have, they have a definition of what they call participating institutions. Okay, and these are essentially financial institution creditors. But if you do not fall within this category, CDRC does not exclude. You can, if you want, you can participate along with the process, and as long as you fall within the same class of creditor as well. Now, for judicial management, Section 366 schemes of arrangement and informal restructurings, they have a much wider scope and will extend to all creditors of the company.
Devon, you mentioned the term creditors, class of creditors earlier. What does this mean? Let's bring Suhendran. Can you shed some light here, Suhendran?
Yes, sure. So the problem is you must get the creditors voting in the same class where their rights are similar as against the company. For example, you could have secured creditors. They will have security, and so their rights are very different from unsecured creditors, for example. As far as unsecured creditors are concerned, this is important. A lot of people ask, look, you have interco debtors, you have subsidiary companies, you have those sort of companies with a relationship with the borrower. Are they entitled to come in and vote together with the other unsecured creditors? Because in a lot of cases, these interco debts can be quite high, and basically they could swamp out the other unsecured creditors. So, and the answer to that is the rights are the same, so they're entitled to come in and vote in the same class. But if they are voting really for the benefit of the holding company or the debtor, then the court at sanction stage has basically the right to discount the votes and then try and achieve some sort of fairness in that sense. And then you have lastly what you would call an essential creditor. In the Megasteel case, for example, TNB, the supplier of electricity, was really an unsecured creditor. But at the end of the day, if you put them in the same category and they would be voted down, what's going to happen is they're just not going to play ball, and they're going to say, no, I want to be paid in full, or at least get a better return, and you have to deal with them, because without electricity, obviously the business just collapses. So the law recognizes you can have essential creditors like this, and you put them in a different class, or you can have a bilateral settlement with them, but outside the scheme. So in that sense, I think there's a lot of flexibility in getting schemes through. So that, I hope, answers your question.
Thank you. Let's bring in Sitpah. Are there any other class which are considered also creditors in your view?
So Suhendran laid it up very nicely. So essentially, the manner of classification of creditors is broadly benchmarked against the similarity of their rights and whether they are able to have a meaningful consultation as a group before they actually make a vote on the proposal. So in this regard, leasing companies may come to be separately classed. Why is that? And first of all, who are they? Leasing companies would be companies who have leased machinery, equipment, even an aeroplane to the business. And why is it they should be separately classed? It's because the leasing company actually owns the asset. It's not the company that owns it, although it seems like that. They have full usage of it, but it's the leasing company who is the owner. And so what does that mean in real terms? Though the leasing company is a creditor to the extent that there are unpaid installments due to them, these leasing companies have the right to repossess this equipment. And because they have and why? Because they are the owner of that. They are the owners of that equipment. And in terms of the law, the courts then do not have the jurisdiction to force upon leasing companies who do not want to give up their rights of repossession by 70%, a majority who agree to give up the right of repossession. And to that extent, because of the ownership interest and the lack of jurisdiction to force it down the throats of dissenting leasing companies, then you have to have them separately classed, and they would then be dealt with on a different basis. Another group could be similar to what Suhendran has mentioned. It could be the inter-company debts, and this could be when you have a subordination of debts. If a banker, say, let's call him a banker B, and he grants facility on terms that banker A and intercompanies are actually agree to take payment only after banker B is paid in full, then, and that has to be an express agreement, then what actually happens is the senior debt creditors, which is Bank B, should separately class. They would paid in full. Their considerations will be different. The junior debt creditors, and they would be separately classed. And sometimes the junior debt creditors may not even be classed at all. Rina, hope that explains what you're looking for.
Yes, thank you very much. But all these options listed applicable to all these companies requiring restructuring, Devon?
Hi. Well, not strictly. Applicability is another one of the characteristics that we need to consider when it comes to which option you should go with. Now, in relation to a CDRC application, this option is only available to companies with aggregate borrowings exceeding 10 million ringgit. They have at least 2 financial institution creditors and have the ability to operate as a going concern post-restructuring, i.e. there must be an assessment by CDRC that they are indeed viable. Now, I know the debt number looks low with RM 10 million, and I find that in our recent discussions with the CDRC Secretariat, he is telling me that, I mean, even if you do qualify for this, I think they're going to be setting the benchmark a bit higher. And the reason why they're doing this is because I think Bank Negara wants the banks themselves to try and restructure their loans internally on their own. Now, if you do not fall within, just say you can't get into CDRC, I mean that you have the option of SDRS. Now, to qualify for SDRS, all you need to do is fall within the definition of an SME. Now, that means you have sales revenue of below 50 million or less, and less than 200 employees. The submission process is similar, but it is done electronically, so there's no secretary which you write to directly. They're quite efficient. They get back to you pretty fast, and there is a set process. In terms of judicial management, you have to the courts must be satisfied of a few things. Now, first, it must be seen that the company is unable to pay its debt. Secondly, it also goes to viability. It can survive as a going concern. And then the other thing that they must be convinced of is approving of a compromise by the creditors would be more advantageous to all involved than the company going through winding up. Now, in the case of informal restructurings in Section 366 schemes, there's no application criteria, so anybody can apply. Now, one thing I found interesting was both judicial management, the CDRC and SDRS route allow for applications to be made by either the company or the creditor itself. I think maybe we can speak a bit more about I could get Sitpah to talk a bit more about the judicial management approach.
Certainly, Davin, that's absolutely right. The judicial management approach is slightly different. The criteria are much tighter. And though it looks like the more attractive option for the company that's undergoing or intending to undergo a restructuring, because of the moratorium that kicks in instantly. As soon as the application is filed, the moratorium against action, and I think they'll speak about that later, what that moratorium is, that kicks in upon the application. But what the company must bear in mind is when they go down the JM route, the judicial management route, they give up management rights over the company. There is an insolvency practitioner, the JMO, the Judicial Management Officer, who will take over the management of the company. At first blush, it looks as if the JM application is ex parte. Why is that? It looks like it because you get an immediate moratorium when you file the application, even before the application is heard. But in truth, then the application must be served. It must be advertised and it must be served on creditors who have a security, say in the form of a debenture, who are able to appoint a receiver and manager. But the thing to note also, and I'll come from both perspectives, the companies and the judicial manager, the thing to note is the judicial management regime can be abused. And we've had a few of that discussions in the Welcome case. The abuse comes in this fashion. And therefore, creditors really have to be vigilant. It comes because the moratorium kicks in upon the application. And once the application is filed, no creditor can bring an action against the company that is intending to go for the restructuring. But in that period of time, the status of the assets of that company may be altered.
Thank you, Sitpah. That's a lot. That's a lot of experience that you have there. But, you know, in your experience, do all creditors cooperate whilst this has been undertaken? You know, what can be done to safeguard the company from legal action by disgruntled creditors? Devon.
Hi, I wish that that would be awesome if everybody cooperated and just let the restructuring take place. But it becomes necessary for a sort of standstill period to be put in place. Now, if you look at the informal route, this does not provide any standstill against creditors. Now, the only time this should be attempted is if, just say, you have a very, very good working relationship with your banks, and they have indicated that they are willing to assist. Now, if you opt for CDRC, there is an informal standstill in place, which remains in place until the scheme is either completed or failed. Now, the informal standstill only applies to financial institutions, though, And whilst it is informal in nature, the local banks do not really want to antagonize CDRC or Bank Negara itself. Sdrs is similar, and it's in their guidelines. They advise banks not to pursue legal action against the borrower. Again, this is persuasive and informal in nature. Now, in terms of the stencils under the Section 366 and under judicial management, I think it's best if this is explained by the lawyers. I'm only what they call a lawyer buruk. So I think probably best if Suhendran takes Section 366.
That's very true, actually, Devin. But anyway, the question about CDRC helping out is what it does is once you're admitted into CDRC, there is an informal standstill with the financial institutions, and this is very, very important. The financial institutions, I mean, you can't blame them. They've already made out so many loans. They've all gone bad, so there can be a little hostility there. So the protection by CDRC and the help by CDRC to help mediate in the matter is actually very important. Now, I'll give an example. In the Mega Steel case, there was a foreign creditor who had picked up loans and refused to submit to the CDRC negotiation or mediation process, and that caused a huge problem. So what we had to do was we had to get a restraining order under Section 366, and what that does is the court will actually provide for a restraining order or a moratorium stopping all persons from suing the company. And now that actually helped in a long way. It stopped the unsecured creditors, the trade creditors, from winding up the company. At the same time, it allowed the negotiations with the bank, and it also kept this foreign creditor at bay. Now, that's a problem with that because, again, it was always subject to an abuse. Now, I'll give an example. You would get a restraining order in KL, and then when that expires, you go to Penang and get another one, and then you go on to Taiping, et cetera, et cetera. And at the end of the day, I think the government had too much of this, and so they put on conditions as to when a court would be able to grant a restraining order. I mean, there are four of them. Some of them are very, very technical, but I'd just like to bring out one, and that is that the court must approve a director who is nominated by the majority of creditors. So if you could just think about that, can you imagine if there is going to be a problem with this company? And the creditors are at the door. They're looking to attach the assets of the company, and that would scuttle the restructuring. How could it be that we would have to the company would have to go and get 50% of the creditors to agree, which effectively gives them a veto right for any restraining order? Now, there was a big argument about whether this applies on the first application or the second application. As it stands now, the two very recent cases suggest that you have to do it immediately on the very first application. And I don't think that works from a practical point of view. The second aspect of this was something that Sitpah touched on, and that was whether you can go ex parte. In other words, what that means is you don't have to serve it on any creditor. You just go to the court and get your restraining order. But the creditors can come back, because you'll advertise, etc., and they can come back to challenge that ex parte order. Now, again, because of the abuses in the past, there was a recent Court of Appeal decision that says, no, you must serve it on all creditors. I mean, that if you read it widely, that's what the case seems to suggest. Now, the problem with that is if you have a huge company, again, I come back to the Mega Steel example, the Mega Steel example, what happened was the total number of creditors total $4 billion. And there were a lot of them. Now, can you imagine that before you go and get an order, you have to serve every single creditor? That would be, come into the thousands. Again, that's impractical. What will happen is some creditors will come and challenge you. You won't get your restraining order. There will be appeals. And that's the end of your restructuring. So I mean, with respect to the Court of Appeal, the facts were very difficult because there was a very clear abuse for other reasons. Again, they did secret applications in different courts, and the Court of Appeal just reacted very badly. But you see, with these sort of problems, the restraining order provisions under 368 of the Companies Act becomes very difficult to implement. And I think we'll touch on how we're going to get around this and what the remedies are. But for the time being, these are the problems. And it makes negotiations with the creditors very difficult if you can't get a moratorium or a restraining order in the manner that I suggested. Rina, I think, Davin, that's about it.
No, it's me again. Oh, wow. It sounds very, very complicated there, Sox. And I think it's very, very time consuming. So, Sitpah, do you have anything else to add, Sitpah?
I do believe you had wanted me to bring in the Hanjin example.
Yes,
and
please.
For that purpose, if I can just pull out a slide. And let's just take that. Thank you. So the problem with the restraining order, or it may even be a moratorium, depending on which scheme you go under, the 366 or the judicial management route, is that the moratorium that is given is very localized. It's local to Malaysia. It binds companies in Malaysia or assets in Malaysia. With shipping companies, however, it is intrinsic in their business that the assets are moving from country to country, and therefore the efficacy or the efficiency of the restraining order has its limits. So Hanjin is a good example to illustrate this. And before we go into why they got into what they did, let me just put it in context that this was around 2016 that they sought the moratoriums, and 2014 they were suffering from the backlash of the crash in freight rates because of an oversupply of ships in the market. They had priced themselves at very high charter rates. They had chartered or hired ships at very high charter rates, and that was one of the reasons they were bleeding. So what happened was, in their timeline, they started in April 2016 with restructuring led by Creditors, and within 10 months some collapsed, and they were in February of 2017. And so if the key factors, you were to look at the lessons to be learned, the key factors would include what their expectations and what they actually took for granted, which therefore did not lead to a successful restructuring either voluntarily or under the court scheme. So we heard Rina mention that they were the seventh largest container shipping line. In fact, they were the largest in South Korea, so they're very much the blue-eyed boy. And they had a fleet of 98 containers, 60 of which they had hired from other foreign and local ship owners. They had huge containers are, the big boxes that we see trailers carrying cargo on our federal highway. They had a capacity of 610,000 100,000 TEUs, 20-foot units. That, to give you a sense, would take Westport 3 weeks, day and night, to just discharge that level of containers. So they were huge. They had debt of 4.9 billion, and they expected US dollars, and they expected to really be bailed out, as was the trend in those days within the government pattern. Government failed to actually give them any form of aid. They had about 34 financial institutions, local and abroad. They were unable to negotiate down their charter rates, unlike the number 2 shipping company, which is the Hyundai company. And so state-owned bank refused any further lending. And their alliances, which is very common for big shipping lines, to have a consortium of liners sharing vessels, sharing services, sharing income from that, they actually pulled back their support. So what was then viewed was actually a total loss of credibility in the company. And one of the reasons why there was that lack of credibility was because there was no fund injected by the Hanjin family into the debt restructuring, and that fueled doubts as to whether there was true commitment into this restructuring process. With their consortium agreements collapsing as well, it meant they didn't have book orders to carry on generating income with shipments on board their ships. So the key factor really for the collapse both of the voluntary restructuring phase and the court phase was there was insufficient funds to manage the operations on the ground. So by August 2016, in fact, Hanjin had to go into court, and they did it in record time, got a restraining order of the sole court to prevent any creditor from bringing any action against them. So that gives them that breathing space really to turn their cash flow around. But what they failed to do was to have enough cash flow, make sure the operations allowed them to assuage the concerns of creditors that were mounting day by day for just ordinary turnaround of your containers. So within a month, they mushroomed about 3,000 trade creditors, and they were largely ship owners, who were saying they're drawing their assistance to clear containers or clear cargo from these ships because they wanted a deposit. They weren't sure that they would be treated fairly in a sole restructuring. And container leasing companies, and here we come to leasing companies, wanted to repossess their own container boxes and exercise lien on the cargo in it. There were, at that point in time, when they went for their restructuring order, $14 billion worth of cargo on our seas, on our high seas, all over.
Incredible.
And Hanjin hadn't moved quickly enough to get corresponding protective orders in other jurisdictions that would reciprocate the restraining order that the sole court had given. And as we said, because the sole order is limited to Seoul, they needed to move quickly. They did not move quickly enough. So what happened was Hanjin found 8 vessels arrested, 43 at sea, and just didn't know what to do. They were just waiting to see what might happen. Maybe there would be a safe harbor somewhere. 39 waiting outside ports because there was a threat of arrest. And so they had to actually get protection orders from 43 different countries.
Oh my goodness, that sounds really incredible.
Some form of holding of hands, have that their sole order of restraining proceedings by creditors recognized under various jurisdictions to get some kind of help. Despite all of that,
thank you, Sitpah. Thank you.
They couldn't contain the problem because there was just a total lack of credibility in the company. Everyone was alarmed at the situation, and so they ended up in bankruptcy, as Rina mentioned, with about 10.4 billion debts by then, US dollars, and only 2% recovery. So really the management of the negotiations and giving enough credibility and commitment, portraying that with sufficient injection of funds that allows the operation to carry on is critical. And the other is when you're getting a restraining order in Malaysia, must be ready with protect papers, that is, papers to file protection orders in other jurisdictions that you think your assets will be traveling, especially for vessels, shipping companies, and airlines for that matter, where your asset is going to be crossing borders all the time.
Indeed.
Rina, so that would be the shipping perspective.
Well, there's no doubt you are definitely the shipping expert amongst a lot of the, I think, world-leading lawyers, especially as well. Now, but given the possibility, the negative connotations of undergoing restructuring and to a share price of a company that is listed, is it necessary for a Bursa Malaysia announcement to be made, or wherever you are listed to be making this announcement, Devon?
Okay, when you decide or not whether to make a restructuring, go ahead with restructuring, whether or not you need to announce, it's different across the different options, right? Now, if you go under the CDRC rule, you have flexibility. Now, this was something that was clarified by the CDRC Secretariat and Bursa's Chief Regulatory Officer. Now, you do not need to announce if you are going, if you're seeking admission into CDRC, as long as it is kept private and confidential, and that there has been no default by the company. If you've defaulted, then obviously you have to make an announcement. Now, that said, if the company still wants to go ahead to announce, this is allowed, but sometimes creditors may get the wrong impression. In the case of informal restructurings, this requires an announcement in the event of default as well. Now, if you're a listed entity, you have to announce the scheme of arrangement, and obviously there could be PN17 repercussions. However, recently, because of COVID-19, these conditions have been temporarily suspended. So that's good. Now, as mentioned earlier, I think you mentioned that judicial management does not apply to companies which are subject to the Capital Market Services Act. So, i.e., listed companies are not allowed. But if you are a subsidiary of a listed entity, then certainly you can apply for judicial management. Now, Bursa's listing requirement states that if you are a subsidiary and you defaulted and you want to go undertake judicial management, you have to make an announcement, and there could be PN17 repercussions as well. Rina?
Okay, so but with all these options discussed today, are these options sufficient to cope with the COVID-19 downturn? What measures could the government put in place to supplement these options to be made more effective? And what examples can we learn from our neighbors around the world? Devon?
If we are going around trying to get consensus from our creditors, I mean, what happens if a creditor disagrees with what is proposed by us?
Beat him up, I think is the only answer. No, I mean, the answer to that is basically it's a negotiation process. And you'll have to go around, start lobbying your best creditors, your friends. Now, this process is going to take a while because everybody has a different idea as to what is good for them. So the negotiation process is critical, and it's going to take a while. And therefore, the moratorium is absolutely critical for the time being. Because of the basically the shortness of time, I think we're running out. I'll leave it at that. I mean, there are lots of tools for negotiations, but that can be done, I think, maybe at another time.
So we're looking at dealing with so many creditors. How about containing consensus with the relevant creditors? What happens if creditors disagree with this proposal? And I think, Sok, you've talked about that. And the options available for Malaysia and what government should do, Devon.
Summarize the options available to restructure. For us, I think the preferred route is Section 366 plus CDRC. Now, whilst there are several options available in Malaysia, including judicial management, voluntary schemes, the lack of success in judicial management today, the loss of control by the entrepreneur and board, limitations in respect to the application to listed companies and secure creditors, and the ability that they have to scuttle plans without cogent reason means that you should look for other approaches. Now, rightfully or wrongfully, just say you you decide to go for a legal approach, this is viewed as confrontational. Now, in debt restructuring, I think the legal approach should be a measure of last resort, and you should always attempt to do a consensus-based restructuring approach first. Now, when it comes to consensus-based, you could do the informal, but if you're going to go on an informal basis, creditors will have great difficulty in trying to sway the banks. They don't have support, and it's just a matter of them trying to influence the banks. Now, this is where we think the CDRC and the SDRC approach is good, because you are able to achieve a considerable amount of success, and there's a right mix of protection provided by the standstill. You have to go on a consensus basis, and there are clear rules in place for CDRC and SDRS. Now, you mentioned whether these options were sufficient and whether they can be supplemented to be more effective. Now, I mean, currently we've got COVID-19 that we're dealing with all over the world. Now, any economic recovery is going to be dependent on the actions of both the government having the right policy response and execution from the service sector, and being resilient and capable of restructuring their business. Both need to happen at the same time. Now, if you look around the world, Australia and Germany have put in measures in place to undertake it. In Singapore, we've got they put in place the COVID-19 Temporary Measures Act. And in terms of restructuring, they've made specific modifications to their Insolvency Restructuring and Dissolution Act. Now, Malaysia has also been doing things, but they've gone through it in the form of regulation. They've not changed legislation yet. Now, recently, there was an increase in threshold for the issuance of statutory demands and time period for companies to respond. They've gone to 6 months now. They've also put relief measures in place by market regulators have also put relief measures in place. Bursa put in the PN17 relaxation. And in March, Bank Negara also dropped its OPR rates, and there could be further drops. And this is done to promote lending. Now, there was talk about reviving Dana Harta and whether or not this would be an efficient means of doing things, especially given how effective they were during the Asian financial crisis. Now, there are pros and cons to reviving Dana Harta, but I see two issues mainly. Firstly, we haven't seen the record spike in NPLs yet. That's not happened yet. And secondly, as a society, I think in Malaysia nowadays, we're a bit more wary of propensity for abuse of power. And we do not want a process which potentially removes the jurisdiction of the courts simply because it is more efficient and expeditious. Now, Suhendran, sorry, could you maybe speak more about Dana Harta?
Yeah, I don't think Dana Harta, with respect, is actually the correct approach for our current problem. Because Dana Harta was set up during the Asian financial crisis and was really to recapitalize the banks and to buy the NPLs. And in doing that, they had the power to appoint special administrators. Now, what that meant was the special administrators would go in and literally take over control of the operations of the company. And these were done by people who, again, with respect, they did not have experience in the business. So what happened was the companies couldn't turn around. I mean, this is not in all cases, but this was in my view, a fault in the Dana Harta operation system when looking at the COVID-19 position, is that assets were sold, businesses died, jobs were lost. Now, to solve this COVID pandemic problem and the financial aspects of it, you have to preserve the businesses. You preserve the businesses, you must preserve your workforce, and the way to do it is what we call a debtor in possession restructuring. And that is the Section 366 scheme of arrangement. So what happens is you come in, the debtor carries on with the operations and then restructures with the help of CDRC to negotiate with the banks. Now, the critical part of that is actually the restraining order. You need protection. And what has happened, I think I've touched on it earlier, is that it's got so strict that you can't get the sort of protection the restraining order required. So you need to relax that. That's number one. And that has to be done by an act of parliament, but that'll take too long. So really regulations are the answer to that. Number two, you do need interim financing, and that financing has to be given priority in case the company fails, because no one's going to lend you any money unless, of course, they have priority in the event of failure. And thirdly, the directors who are actually carrying on trading while trying to restructure must be given relief from insolvent trading. That's very important. Otherwise, they just wouldn't dare go on and carry on trading to try and revive the company. All of this needs to be done by a government act. And what is Singapore has done it through an act of parliament, but they did that very, very early. We have the problem of passing the procedure of passing an act takes a long time. And current information is that the COVID bills are only going to be heard in July. And the first sitting is going to be on the April 18th, but that's only going to be for one day. So regulations is the key. And actually IPAM, which is the Insolvency Practitioners Association of Malaysia, we've come up with a set of regulations. We put papers to the minister and the government, and hopefully we can get regulations done. There are question marks about this process, but we have no choice. And we think legally it's possible, and hopefully we can put this into play very soon. Thank you.